she didn't have the two critical pieces of information the police wanted,
Okay.
namely what happened to Jennifer Dulos and where's the body.
What do you think about this technique, this ruse technique?
Police have been using this technique for a long time in all kinds of cases, but they rarely use it in front of a defense attorney.
Yeah, I'm going to object to the form of the question. I can't understand it.
I did understand it. If the witness does, you may answer.
For that to roll out of her mouth on June 6th without her lawyer having any idea that she had that information or was prepared to say it is ludicrous. The reason Attorney Bowman didn't put a stop to it was because he thought in the end his client could handle it, and ultimately her answers would be advantageous to her.
Yeah, that makes you wonder, again, looking back on those videos, that should he have stepped in and said something?
Good afternoon. Please be seated, ladies and gentlemen. Mr. Fitzpatrick. And counsel, I understand you had another matter at 2 o'clock.
Thank you for that. Thank you, Your Honor.
Thank you, Your Honor.
Continued cross-examination, Mr. Zentner, when you're ready.
Yes, thank you, Your Honor. Okay, good afternoon, Attorney Fitzpatrick.
Good afternoon.
When you were retained as an expert in this matter, did you prepare any kind of report for Attorney Brown?
No, I did not prepare a report.
You have prepared a report when you've testified as an expert in other habeas matters, though. Isn't that correct?
Sometimes.
And one of those reports was for Attorney Brown in the Figueroa case.
I don't recall.
Please have a moment, please, Your Honor.
Yes.
Okay, let me move on to the next question. I'll circle back. Do you recall whether or not you did a report in the Friend habeas matter for Attorney Kirschbaum?
I don't recall whether I rendered a report in that case.
Mr. Fitzpatrick, let's circle back for a minute to the Figueroa matter. If I showed you a report in that matter, would that perhaps refresh your memory?
Yes. Thank you.
Okay, Attorney Fitzpatrick, having seen that report, did that refresh your memory as to whether or not you did a report for Attorney Brown in the Figueroa matter?
Yes.
And did you do so?
Yes.
You said you didn't do one in this case.
That's correct.
You understand that if you had done a report, that would have been disclosable to me.
That's a decision for Attorney Brown to make under the rules of evidence and the rules of civil and criminal procedure.
Now, you testified last Friday on your direct examination that you had one time defended Attorney Bowman to the media on the Giordano matter, right?
That's correct.
And just again to recap, Attorney Bowman had represented the former mayor of Waterbury named Philip Giordano on allegations involving child sexual assault.
I believe that's correct.
And Mr. Giordano at one point had filed a federal habeas claim against Attorney Bowman.
I believe that's correct.
And do you recall a newspaper reporter from the Connecticut Post by the name of Michael Mako reaching out to you in that matter?
Yes.
And when asked about the claims against Mr. Bowman in the Giordano matter, your response to Mr. Mako was that, just hold on a moment. You said that Mr. Giordano had a incredibly difficult battle because, in your estimation, Andy Bowman was a preeminent lawyer. Isn't that what you told Mr. Mako?
Remember what I said was favorable. I'll take your representation of that's what is contained in the article.
Okay. So you'll accept my representation. There's no need for you to have your memory refreshed. Is that fair?
No, as an officer of the court, I'm sure you would not misstate the article.
Okay. When you gave your opinion, when Mr. Mako reached out to you in the Giordano matter, and you gave your opinion about Mr. Bowman in that case, you weren't paid a dime for that opinion, were you?
That's correct.
In contrast to your testimony here, where apparently you're going to be receiving so far over $30,000.
I think you're just stating the obvious.
I take that as a yes.
I'm being compensated for my time in this proceeding.
Do you recall being hired by NBC News in the Troconis Trial on a segment by NBC News called Inside the Troconis Trial?
I was not hired.
Did you?
I was not paid. That's what I mean to say.
Okay,
So
you were not paid for that at all. That's your testimony?
there was no compensation for that.
Okay. But you were hired by NBC News to be an objective observer of the jury proceedings, like in State versus Michelle Troconis, correct?
Yes.
And do you remember being interviewed on that inside the Troconis trial by a TV reporter by the name of Shannon Miller? Do you recall that?
Yes, I know Shannon Miller.
Okay. How long had you known her?
Probably not when she began working at NBC Connecticut, but sometime thereafter. Probably beginning with the debate case is when I got to know her.
That was a case tried in this particular courthouse?
Tried in this courthouse, yes.
And she, on a particular date in late January, specifically January 29th of 2024, she interviewed both you, an attorney by the name of Trent Lolima, correct?
That's correct.
And both you and Mr. Lolima had represented Mr. Debate in this courthouse, right?
Yes.
And on the date of January 29th of 2024, and withdrawn, you testified on your direct examination that there were points during the 3 interviews of Ms. Troconis, where Mr. Bowman was sitting next to her, the dates of June 2nd, June 6th, August 13th of 2019, where you opined that Mr. Bowman should have shut it down when they were asking her difficult questions or didn't believe her. Do you remember that testimony?
Yes.
Do you recall being, when you were interviewed by Ms. Shannon Miller on January 29th, 2024, she asked you about a certain portion of the transcript, a certain portion of the video, the interviews, where police sometimes confront someone they're interviewing with false evidence or a ruse, something of that nature. Do you recall that?
I do not recall that exchange with Shannon Miller.
Okay. If I played you the video, might that refresh your memory as to what you said to Miss Miller?
It might.
Your Honor, if I could just inquire of the court, will that be played on the TV there?
I guess the answer is yes.
Your Honor, with the court's permission, may I stand next to the TV so I can see it too?
Yeah, may I also?
Of course.
Yeah.
If this was a trial, you would have a jury of 12 people, and they would be told the story, and then they would have to say, is that a reasonable story?
And that is just part of the interview played in its entirety for the jury on Friday, where it mentions those jury members themselves, 12 of Michelle Troconis' peers tasked with deciding her fate. Welcome back. We are here once again with attorneys Trent Lolima and Mike Fitzpatrick. So let's talk about this ruse interrogation technique that we learned about last week. It was first used in that first interview that Michelle Troconis gave detectives when they pulled that picture of that bloody pillow before her and said, this is, Jennifer's blood, although they did not have that information confirmed at the time, nor was that bloody pillow ever found. I want to play you now what Brian Foley said, a former Hartford police detective and spokesperson for state police at the time of Jennifer's case.
As an investigator, you think to yourself, this person's lying to me and lying to me nonstop and changing the story so many times. I'm going to try and throw a lie back at them to get them back on the truth. As long as you're open about it when it comes out in front of a jury, and look at when you use that ruse, that's not your only evidence. You're using that to gather further evidence. So hopefully the witness, in this case, Troconis, she offers up something that will point these detectives in another direction. So it's not what's said there that's going to be the key piece of evidence. You use that ruse to get to get pointed in the right direction to gather further evidence elsewhere.
Michelle maintains that she was telling investigators the truth throughout all of these interviews. She was trying to help them fill in the gaps, saying, I don't know about Jennifer Dulos' disappearance. What do you think about this technique, this ruse technique?
Police have been using this technique for a long time in all kinds of cases, but they rarely use it in front of a defense attorney. They did it in this case. They did it in each interview. And I have to believe that the reason Attorney Bowman didn't put a stop to it was because he thought in the end his client could handle it, and ultimately her answers would be advantageous to her.
Yeah, that makes you wonder, again, looking back on those videos, that should he have stepped in and said something?
Well, I mean,
The reason you're there as a defense attorney is you want to avoid.
Okay, so when you were asked, when you were not being paid, and you were the role you said of being an objective observer of the proceedings, when asked about why Mr. Bowman didn't stop it or should have stopped it, your answer again was, I have to believe that the reason Attorney Bowman didn't put a stop to it was because he thought in the end his client could handle it and that ultimately her answers would be advantageous to her, right?
Yes, that was my best estimate or my best guess at that point in time as to why he allowed that to occur.
Okay, and that would be consistent with what Mr. Bowman testified to in this court.
I don't think you could distill all the testimony he gave in this court down to that one point.
After you gave that answer to Miss Miller, you may recall looking at the video, and hopefully that has refreshed your memory. She said, Shannon Miller, it makes you wonder again, looking back, if Andy Bowman should have stepped in and said something. And when she said that, you stayed silent. You didn't answer that question.
Your Honor, I'm thoroughly confused about the.
Yeah, you've made statements. You just have to ask questions.
Do you remember when Miss Miller then commented, it makes you wonder again, looking back, if Andy Bowman should have stepped in and said something. When Miss Miller said that, you did not say a word. You stayed silent.
It's irrelevant.
Well, you've asked two questions. Just ask one at a time.
Did you remain silent after she made that comment that looking back, maybe Mr. Bowman should have stepped in and said something? You remained silent then.
Yes. You want to ask me why?
There's no question pending, Mr. Fitzpatrick, right?
Then why did we just get all the commentary? There's no question attached.
Well,
to
the witness made first commentary. If you want to ask that question on redirect, you may, Mr. Brown.
But again, 6 weeks before that, on NBC News, you were prepared to testify at the suppression hearing on behalf of Ms. Troconis, December 18, 2023.
Yes.
Okay, moving to another line of inquiry. You testified that the representation of a client really begins when you meet with the client and get a history and get to know the client. Remember that?
Yes.
And that is also done, you would agree with me, in part to size up the client as well.
Yes.
Mr. Bowman did that in this case on May 29th, 2019. He met with her Ms. Troconis for 2 hours. He got a history of her. She provided what she said was a timeline. Do you remember that?
I recall the testimony. Whether
Is that a yes?
the answer is yes, I do not agree that an hour and a half was sufficient time to meet with the client.
And I'm going to move to strike the last portion of that answer as non-responsive.
I wasn't clear whether the question called for it or not, so I'll allow it to stand.
And then part of the initial meeting, when you meet with a client, is also in an attempt to try to determine as best you can the scope of that representation, what it may involve. You try to get an idea of what it may involve. Fair enough?
The scope of the representation always has to be determined, and it's generally set at the end of the meeting so that the client understands what the lawyer is going to do and the lawyer understands what the client is going to do.
But sometimes in your experience practicing law for nearly 40 years, you don't always do a retainer agreement right away. Sometimes you want to think about it and think about what might be an appropriate retainer, right?
That's correct.
You've had that experience I don't want any names, obviously, but you've had that experience where you've thought about, when you look after they leave, I wonder what might be an appropriate retainer for this kind of a case based on what they told me. Sometimes you want some time to think about it yourself.
That's in fact what happened here, and I don't quarrel with it.
You talked about this idea of sending what's called a Stoddard letter. Do you recall that in your direct examination?
I think it was Attorney Brown that used the phrase Stoddard letter.
Okay. But you know what that is, correct? You've heard that phrase before?
Yes.
That's, just for the record, it's clear, that's from a case, I think from about 1988 from the Connecticut Supreme Court.
The Stoddard case actually started in the town of Fairfield at the Fairfield Police Department, and the lawyer's last name was Fitzpatrick.
No relation to you, though.
No relation to me, but in that case went all the way to the Connecticut Supreme Court.
Right. And without getting it, that was a case that sort of distinguished Moran versus Burbine, right?
Right.
Okay.
Because what happened in that case was the lawyer went to the police department and wanted to meet with Stoddard, and the police would not allow it. In fact, I think they didn't even want to tell the lawyer that Stoddard was in the lockup.
Okay. In this, one purpose you would agree with me of a Stoddard letter is so that the police are aware that they should not speak to the client because you've so advised them. Correct?
I'm sorry, you tailed off.
My apologies.
The police should not speak to the client because of,
You represent the client and you are then putting them on notice. You do not want your client to speak to them, right?
correct, and that you represent the client and that no interview should take place unless and until the client waives his or her rights and counsel is present.
Okay. In this case, you recall the testimony of Mr. Bowman that twice he told the police she's declined to speak to you. This is on around June 1, June 2 of 2019.
Right. It would have been sometime in the morning on June 2nd. On two occasions, he told the police that Ms. Troconis was not going to submit to an interview.
It was clear early on in the investigation, it was unclear which agency would be the investigating agency. Was it going to be which, for example, was it going to be which major crime district would be involved in the investigation? Would it, for example, be the Central Major Crime Squad? Would it be Western Major Crime Squad? It was not clear. Was it going to be the New Canaan Police? Was it going to be Hartford? It was not clear in the beginning, right?
Clear to who?
To anyone, to Mr. Bowman.
I don't know what was clear or not clear to Attorney Bowman.
If you had a client, Attorney Fitzpatrick, who was inclined to speak to the police and cooperate, after you counseled them, you would make it patently clear to that client, you have a right to remain silent, but if you want to go in there and speak to the police unequivocally, without question, you have to tell them the truth.
Sure. I think the standard is what a reasonably competent attorney would do, not what Attorney Fitzpatrick would do under particular circumstances.
All right. You want to
I'll rephrase.
question?
Same question. Instead of you, meaning you yourself, Mr. Fitzpatrick, would a reasonably competent attorney who has a client who wants to speak to the police and cooperate, would a reasonable competent attorney counsel the client that that person has a right to remain silent, but if they are so inclined to speak to the police, without question, you have to be upfront. You must tell the truth to them. You cannot lie.
Does your question incorporate the absence of protection?
No. Take it at face value, the way you look at the video. That question by itself.
A reasonably competent attorney would do that and more.
You've opined about Mr. Bowman's thought process, even though you don't know what Mr. Bowman was thinking about, what he was clear about, right?
I only know what was revealed through his testimony in this courtroom.
Because again, you never asked for or received his notes.
His notes? No.
You said one of the purposes of the initial meeting with a client is to get the facts from the client, right?
Yes, the historical facts.
Isn't that what Mr. Bowman did here with that timeline that she provided to him that was reduced to writing?
I think he would have done that without the timeline. It's one of the most essential functions of an initial meeting with a client to ask what the client knows about the crime that's under investigation.
And that's what he testified to at the initial meeting, asking about the timeline, right?
He testified that they discussed the timeline. I didn't see his testimony as being limited to just the timeline. It does seem like he discussed with Ms. Troconis the matter that was under investigation.
You're aware that he met with Ms. Troconis several times during the week of June 3rd of 2019, that Mr. Bowman met several times with Ms. Troconis at his office.
He said there was more than one meeting in between the first interview and the second interview.
You testified also on your direct examination that you did not want to be tainted by the distorting effects of hindsight. Do you recall that?
That's correct.
But yet you went on to watch the state's rebuttal argument in that case at the jury trial.
The videotape?
Yes.
Yes.
It could be argued that if the defense attorney had shown the state, withdrawn. It could be argued that had the defense attorney shown an arrest warrant to a client, and the client reads all the the application or the affidavit and then goes in for the interview, that could leave the client open to saying you shaped your answers based on the reading of the warrant. Couldn't it be argued hypothetically?
Hypothetically, yes, but it wouldn't excuse not showing the warrant affidavit to the client.
Stopping the interview all of a sudden could be viewed. Would you agree with me, Attorney Fitzpatrick, that stopping the interview all of a sudden could be viewed as a refusal to cooperate and balking on the agreement and having any consideration withdrawn? Hypothetically.
No, because there was no agreement.
Okay. That wasn't the question.
Well, you used the word agreement, and it was embedded
Even
in
a
your
verbal
question.
a verbal agreement.
There was no verbal agreement either. If you're asking me,
There's no question pending.
okay.
Let's talk a moment about cooperation and proffer agreements, okay? On a proffer agreement that is utilized by the federal authorities, one of the paragraphs makes clear that the client, does not have any more protection from prosecution for perjury, false statements, or obstruction of justice, or any other offense he commits on the date of this agreement. And the statements and information used by the client provides at this meeting that they may be used against him without limitation in any such prosecutions. So on a proffer agreement, if you lie to the authorities, a material lie, that makes that agreement null and void, right?
You're asking me questions about a document I haven't seen.
Do you want to take a look at it?
Yes, please. Thank you. Yes, thank you for that opportunity.
You have sufficient time to read it?
Yes,
You would agree with me that paragraph 8 of the federal proffer notes that the agreement is null and void if you have been found to have intentionally provided false, misleading, or inaccurate information at the meeting, right?
well, that's what I'm going to take your word for it. That it's paragraph 8.
As an officer of the court, right?
Right. That's a standard proffer agreement. I'm very familiar with them. I'm very familiar with that.
Because you've had clients who've cooperated in federal court, right?
Yes. Yes. I have experience in federal court with proffer agreements, cooperation agreements, plea agreements.
With regard to an example of a agreement concerning prosecution at the state level.
Previous agreement was exhibits F.
I'm sorry. My apologies. Now, the first one I referenced for the record would be defendants exhibit S's and Sam.
Okay.
And then the prosecution agreement, which I'm now going to ask Attorney Fitzpatrick about, would be defendants exhibit K. Okay. With regard to the state cooperation agreement, do you want me to show you that so you'll get familiar with it, Attorney Fitzpatrick, just like you did with the federal proffer?
Please. Thank you. You want me to review the section that says optional?
Sure.
Is this a standard agreement if it has an optional section?
Well, have you ever seen, let me ask you this. I have to read the microphone. Have you ever seen a cooperation agreement where it is not, where there has not been a reference to the fact that if you give a material false statement, if you mislead, if you give an incomplete statement, that will render that agreement null and void,
Correct.
right? So it is imperative that the client tell the truth when given a cooperation agreement or a proffer, correct?
Well, a proffer and a cooperation agreement they're related, but not the same thing. But
Okay.
with regard to both agreements, it's essential that the client tell the truth because the client can be prosecuted for lying if the lie can be proven.
And in this case, based on your review of the entire record, there were material lies in this case by Mr. Troconis.
Well,
I could be more specific if you'd like.
I'm going to say there were arguable lies. Okay.
Well, what about the part where she does a timeline that she hands to an attorney, which she said she wrote. And in that timeline, she notes at 6:40 a.m., Fotis Dulos joins her in the shower. That was a lie, wasn't it?
I'm not in a position to characterize something as a lie. If Ms. Troconis indicates in an interview that that is not a truthful statement, I leave it to the record. But I'm not able to characterize whether something is an inconsistency or a falsehood or a blatant lie.
Well, did you see the second warrant that was served or executed on Ms. Troconis from September of 2019?
Yes.
And you saw Mr. Bowman's testimony that when he reviewed that warrant, the affidavit, the application, he noticed that the Tacoma that Fotis Dulos was driving that day was going by the Fairfield Rest area on the Merritt Parkway a little after 6:30, and near the New Canaan Rest area, also on the Merritt Parkway at around 7:09, right?
He did note that in his testimony.
And that convinced him definitively, unequivocally, that her claim that she was in the shower with Fotis Dulos was not true.
I think we at least need clarity on the question. Is the question what the truth is, or what Andy Bowman believes the truth is? What I think we're kind of afield from even.
I interpreted it to ask whether those facts convince Mr. Bowman. Am I correct?
It's also to show that even if such an agreement had been executed, a cooperation agreement, those type of material lies would have rendered that agreement null and void.
You didn't ask that.
I'm going to.
Okay.
You would agree with me that if that was indeed shown to be an untruth, a lie, a material misrepresentation, that would have rendered a cooperation agreement null and void. Would you agree with that?
You want me to speculate on that?
I'm not asking you to speculate. What do you think? You don't think that would have made it, in your opinion, would that have rendered that agreement null and void, that type of material misrepresentation, that she was in the shower with Fotis Dulos at 6:40 a.m. on May 24th, 2019?
So I would have to guess how Attorney Colangelo might handle it, and
I
he
would-
may very well conclude.
Then I would move to strike. It calls for speculation about how Mr. Colangelo would handle
Well,
it.
then you're striking your own question.
I'm striking as non-responsive.
I think it was responsive. You asked him to render his response to your question. He said he'd have to speculate.
So I object. Calls for speculation if it's late. I
Well, I've
apologize.
already said that.
Has the court then overruled that objection?
You can ask him, but you can't say that his answer is untruthful if he believes that he's unsure whether Mr. Colangelo would void the agreement or not. He has to say that.
In your estimation, would you have a fear that that type of misrepresentation would render that agreement null and void? Would a reasonable and competent attorney have that fear that that misrepresentation would render the agreement null and void?
Assuming there was an agreement in place
Yes.
in the first instance, sure, that would be a concern of a reasonably competent attorney.
And wouldn't another concern of a reasonably competent attorney be that when she indicates to the police on the first interview on June 2nd, 2019, that she saw Fotis Dulos and his friend attorney Ken Mawini in the office at 4 Jefferson Road sometime between 8 and 8:15 in the morning, when that was shown to be untrue, having looked at that warrant from September of 2019, would that concern a reasonably competent attorney that she had lied to the police?
Yes. And it concerned Andy Bowman. You could see the look on his face on the June 6th videotape.
Again, Your Honor, there was no question pending.
Right.
I move as
As to
non-responsive.
that part, the witness was not asked whether it concerned Andy Bowman.
I would respectfully
I'll
ask the
disregard
court.
it.
Thank you. And you saw in the agreement that if it's shown to be a material lie under the state cooperation agreement, that could give rise to charges possibly involving perjury and hindering prosecution and making a false statement.
The answer is yes. What I should say is this: you obviously,
Mr. Fitzpatrick, it just calls for yes or no.
You didn't say that in the question, but my sense is that the answer was going beyond the question. You'll have redirect.
You also said in your direct examination that the police are in the business of prosecuting. Do you remember that? Or you don't recall that?
no, the police are in the business of investigating crimes.
So is it fair to say if you said that you misspoke on your direct examination?
Yeah, state's attorneys are in the business of prosecuting.
Okay. I just want to, all right. Thank you for clarifying that.
Yeah.
You said you reviewed all 3 videos in its entirety, right? From June 2nd, June 6th, and August 13th, 2019.
Correct.
You claimed on your direct examination that she was emotionally distraught. Do you recall that?
Yes,
George Randolph, however, did not make that finding, correct?
that's correct.
You also indicated that she was exhausted in the interview. Judge Randolph has concluded just the opposite, that she was alert,
Asked and answered objection.
I'll allow it.
right?
Yes,
You also indicated that the interview of June 2nd of 2019 was not in her language, right?
correct.
But it's fair to say that she never asked for a Spanish interpreter anywhere in those videos, right?
You had asked me that earlier. I said not in those express terms.
Okay. You were aware that from Judge Randolph's memo of decision that her mother indicated, Ms. Troconis' mother, that Michelle Troconis was smart, right?
That's correct. I did see that in his decision.
And that she had an equestrian degree, something involving horses, right?
I saw that as well in the decision.
Okay. And also, did you note in the decision that at one point, it's unclear, but she was a reporter for ESPN in Argentina covering soccer?
I also saw that.
And did you recall Attorney Bowman's testimony that in his estimation, Michelle Troconis would present as sincere, and that she would present as sincere, that she would present well? Do you recall that? Mr. Bowman's testimony I'm referring to.
Yes, I think the answer is yes. That seems to be based on his interaction with her on May 29th, as opposed to his interaction with her just prior to the June 2nd interview.
Okay. As you indicated in your testimony earlier, you've never spoken to Michelle Troconis as a preparation of this case.
That's correct.
Do you recall that Judge Randolph noted in his decision that Ms. Troconis told Sergeant Hazen, who was transporting her, that she had no difficulty understanding English? And that was referenced in Judge Randolph's decision.
I don't know if I completely agree with the way the judge put it in his memorandum of decision on that particular point. I don't think Michelle Troconis said to Detective Hazen on the ride down, I have no difficulty understanding English.
All right, let me circle back to that for a moment, Attorney Fitzpatrick. Judge Randolph also noted, I think in his memo of decision, that at the time of her interview, Michelle Troconis was 45 years of age. Do you recall that?
Yes,
Do you recall early on in the video that when Michelle Troconis has read her rights, she signs indicating that she understood the notice of rights?
this is when the police and Attorney Bowman are present.
Correct.
She executed the notice and the waiver.
Correct. Now, you testified also on your direct examination last Friday that when you watched the videos, you took them at face value. Do you recall that?
I don't recall that.
Right. Is that something you would say?
I don't know. Can you put it in context for me?
Okay, let's go through them one at a time, okay? At one point, at the conclusion of the first interview, Attorney Bowman says to the interviewing officers that near the end of the first interview of June 2nd of 2019, Attorney Bowman says to the officers, I spent a lot of time with Michelle, and there is a lot she cannot be precise about, and that he does not see her lying, only that she could be wrong or inaccurate, and again states he does not see her as lying. Do you remember that part of Mr. Bowman's comment to the police at the end of that interview?
Yes.
You would agree with me that that was an example of Mr. Bowman advocating for his client to perhaps explain some inconsistencies.
I would agree that's an example of him advocating for his client.
Okay. You would agree with me that Mr. Bowman is a very seasoned and experienced attorney.
Yes, I would.
So when Mr. Bowman made that comment to the police at the end of that interview, there's nothing deficient about his performance there. He's advocating for his client in the best way he can.
There is nothing deficient about making that remark. In fact, it goes to one of the three basic duties of a defense lawyer, the first of which is advocacy.
Okay, and he did that in that situation. Fair enough?
By that remark. He also made a similar remark at the 1713 mark of the videotape.
Did you also notice in Judge Randolph's decision of December 20th of 2023 that he noted several times in both the factual part of the memo and then the analysis that Ms. Troconis answered questions without hesitation. Do you remember that?
I read that in the opinion.
Okay. And at times, Judge Randolph noted that at times, Michelle Troconis would correct the Kimball understanding of what she had said. He mentions that as well a few times,
I
correct?
read that too.
Okay, so now, Attorney Fitzpatrick, I would like to direct your attention to the second interview, so just that you and I are on the same page, okay?
Yes.
You claimed on your direct examination that, in your opinion, Mr. Bowman should not have acquiesced to his client submitting to a second interview on June 6th because you believe that, what is she going to now tell them that she didn't say before? What is she now going to tell them that they didn't already know? Remember that?
I don't think I ever used the word acquiesced. I don't think it was a
That's my word. You said he shouldn't have agreed to it. How's that?
second interview should have never taken place.
And one reason you said it should never have taken place is because he should have known that she's not going to suddenly give them additional information that she didn't already say at the first interview, right?
I'm sorry, say that again?
That he should not have agreed to it because she's not suddenly, Mr. Troconis, going to give them information that she didn't already give to them 4 days earlier.
Well, that's part of it. I think the larger part of it is she didn't have the two critical pieces of information the police wanted, namely what happened to Jennifer Dulos and where's the body. And if that's the point of the interview, then there's no point to going forward with it if your client doesn't have the information.
But they could seek other information which may be helpful. You agree with that?
They could, but they made it very clear that they weren't there for that. And that was such information was completely secondary. It was ancillary. It was not their principal interest. And if you watch the first 11 minutes of that June 6th interview, it's abundantly clear that it got off to a terrible start and it should have been shut down.
Okay. You recalled Attorney Bowman's testimony, having represented many, many clients over 55 years, or maybe 50 years, because he was a U.S. attorney for a little while there, that cooperation is really counterintuitive. In other words, that clients don't always give you everything at first, and that they believe that if they hold back, it's going to be more advantageous. But in fact, the opposite is true. The more you offer, the more valuable you become to the government or the state, right?
I don't disagree with what he said about the counterintuitive principle, but the notion that Michelle Troconis was somehow on June 6th, all of a sudden, without having told Andy Bowman previously that she knew what happened to Jennifer Dulos and where the body is, I think is just...
Well, let me ask you this.
To expect that to happen on June 6th, for that to roll out of her mouth on June 6th without her lawyer having any idea that she had that information or was prepared to say it is ludicrous.
Okay. Again, she met with during the week of June 3rd of 2019. Mr. Bowman met twice with Mr. Troconis in his office. Do you recall that?
Yes.
You were not there for those conversations, right?
I'm sorry, give me the date again.
Of June 3rd, 2019, which was a Monday. The court
June
could take
3rd.
judicial notice that June 3rd, 2019 was a Monday.
Correct.
Okay. Mr. Bowman testified he met in his office with Mr. Troconis that week, right? Before the second interview.
That's correct.
Okay. You, Mr. Fitzpatrick, have no idea what they discussed with each other during those two meetings because you were not there.
That's correct.
And again, you didn't ask for his notes, right?
Well, let me put it this way.
Is that a yes or no? You know, just calls for a yes
I
or
did
no.
not ask for his notes. But if you're suggesting...
There's no question pending.
It was a yes or no question.
Do you recall, Attorney Fitzpatrick, on the second interview that took place in Mr. Bowman's office, that at one point in time, some point during the interview, State's Attorney Richard Colangelo makes an appearance? Do you remember that?
Yes.
And that Mr. Colangelo at one point says to Ms. Troconis, "We wouldn't be here. I wouldn't have talked to your attorney, and asked you to come in if I thought in a second that you knew what he," meaning Fotis Dulos, "was going to do. I wouldn't. I wouldn't waste our time because I would have just said, arrest her." Do you remember that?
Yes.
So when you look at that statement, an argument could certainly be made that Mr. Bowman was making inroads in terms of convincing the prosecution that she would be a valuable witness as a cooperating witness?
Objection to having this witness upon that, especially when Attorney Colangelo was even already here to be asked about that.
I think it's within the scope of his expertise overruled.
Should I repeat the question, sir?
No, and I think I can answer it in this way. I'm certainly not in Attorney Bowman's head to be able to say that he thought inroads were being made, but he certainly did testify in this proceeding that he thought in the second interview progress was being made.
Okay. You also recall later, maybe a few moments after Mr. Colangelo makes that comment to Mr. Troconis, that State's Attorney Colangelo says, "We're here because I think you can help." Do you remember that?
Yes.
How about when Attorney Colangelo also tells Mr. Troconis, you're trusting, and that's understandable. Do you remember that part?
Yes.
And how about, you remember there at that, one of the officers by the name of, there was an officer by the name of Sergeant Ventresca. Do you recall that, Attorney Fitzpatrick?
Yes.
And there was a point in time on the video where Mr. Troconis and Attorney Bowman step out of the room, but it's still being recorded. Do you remember that?
Yes.
Okay. And Detective Ventresca says to his colleagues, including maybe Mr. Colangelo in the room, he says, I mean, I don't know about your guys' thoughts, but I don't think she's holding anything back. I don't think she knows. Do you remember that?
Yes.
It's fair to say, all those things considered, the comments by State Attorney Colangelo, the comment I just read by Sergeant Ventresca, it's fair to say that one can conclude from Mr. Bowman's point of view that he was making inroads in terms of Michelle Troconis being a cooperating witness. One could draw that inference.
Well, all that occurred in the middle of the interview. The balance of the interview didn't go particularly well, and
Okay.
she certainly started off terribly. So I'm, looking at it in its totality, I think a reasonably competent lawyer would conclude that on balance, Michelle Troconis did not perform well.
Well,
And-
let me ask
and
you this.
question the reason for even having the interview in the first place.
Well, that interview was a little over 3 hours, wasn't it?
Yes.
Well, if you looked on the videotape at the 3 hour and 40-minute mark, did you recall observing one of the officers telling Mr. Troconis, you are helping us out at this point, right? Near the end of that interview.
That's when she agreed to take them to various parcels of land
With Attorney Bowman.
with Attorney Bowman.
So she was cooperating and being helpful there, supposedly, right? Did you answer that question, Mr.
So she was cooperating?
Yes. She's offered to take them out, sort of what you and I would call a field trip, along with Attorney Bowman the following day or so, right?
Well, she offered, and what I understand is that did in fact happen. So yes.
Did you see the part in the second interview when Mr. Troconis tells the officers, I'm sorry, withdrawn. Did you see the part, Attorney Fitzpatrick, in the second interview where Ms. Troconis acknowledges that Mr. Bowman is serving her interest?
That I don't recall.
Well, if I showed you the transcript, would that refresh your memory?
Sure.
Okay, just have a moment.
Yes.
May I approach? I'm sorry, again, it's such a hard habit to break. Right, Mr. Fitzpatrick, this is the transcript from June 6th, 2019. And for the record, it looks like it's in section 0002, and it's on page 55 of 87, so the record is clear, okay? Do you want to just take a moment and read? Sir?
Sure. Okay, thank you.
Memory refresh, sir?
Not really, but I trust the transcript.
Well, you would agree with me that the transcript, she does acknowledge that Mr. Bowman's serving her interest, right?
Yes, well, he's her lawyer, so obviously.
Okay. Do you recall, I'm going to now jump to the third interview, okay? So you and I are clear about what I'm talking about, okay?
Yes,
So, Mr. Fitzpatrick, on the third interview, which is again dated August 13th of 2019, at the end of that interview, Attorney Bowman tells the police that Ms. Troconis is trying her best and is frightened. Do you recall that?
yes, I do.
You would agree with me that that was an example a reasonably competent attorney would make a comment like that in order to, again, perhaps explain any inconsistencies that they may perceive.
Yes, he's serving in the role as an advocate.
Nothing deficient about that, right?
No, he's doing his best to vouch for her credibility or lack thereof, or to rehabilitate any lack of credibility.
You also stated, I think this didn't come up on my cross at all, but on your direct examination, Attorney Fitzpatrick, from Friday, one of the materials you reviewed was the 6.5-page letter that Mr. Bowman provided to Mr. Colangelo, dated August 27th, 2019. Do you recall that?
Yes,
You would agree with, did you have a chance to review that letter?
yes,
Okay. You would agree with me that that letter was a piece of advocacy that a lawyer was making on behalf of a client.
that's correct.
Okay. Nothing deficient about that. You agree it was a well-worded letter? Well-written?
Yes,
And Mr. Bowman identifies the reasons as to why, in his estimation, she would be a credible cooperating witness.
he did.
Okay, Mr. Fitzpatrick has an attorney for nearly 40 years, and you practiced in this state exclusively for close to 40 years. Is that fair?
That's correct.
You would agree with me that if you have a long-standing professional relationship with a prosecutor, one based on mutual respect and mutual trust, that is something that would certainly bode well for you and your client in your dealings with a prosecutor. Would you agree with that?
I'm sorry, repeat that.
Sure. It's kind of a long question, so stay with me if you can. I know it's late.
Long-standing relationship.
Yeah. If you are dealing with a prosecutor on a given criminal case, okay, in your experience, a reasonably competent lawyer, if that reasonably competent lawyer has a good professional relationship with that prosecutor, okay, that relationship is based on mutual respect and mutual trust. That is something that will only bode well for you and your client in your dealings with the prosecutor on that particular case. Is that fair to say?
Conceivably, it should.
And that's something you've enjoyed yourself in your dealings with several prosecutors around the state.
Yes.
Okay, thank you very much, Your Honor. I think that concludes my cross-examination of Attorney Fitzpatrick.
What's your pleasure, Mr. Brown? We'll either take our afternoon recess or you could begin redirect.
I don't have a strong preference. I clearly leave it to the court. I'm fine with either.
Okay. All right, let's start redirect then.
Okay, so you were asked a bit about the value of a strong relationship with a prosecutor and a state's attorney, and you're asked about the interview with Attorney Colangelo and the comments he made in the second interview. Remember those questions?
Not to interrupt you, but the screen is.
Oh, I'll
view.
I may have to go back and forth a little bit, but I'll start over here.
Yeah, I'd like to be able to be able to hear you clearly. Sorry.
Absolutely. You were asked about the value of a relationship with a prosecutor being based on trust. You were asked about the comments that were made by State's Attorney Colangelo during that second interview.
Yes.
Do you review the arrest warrants in this case?
Yes.
Do you know who signed those arrest warrants?
I believe. Well, I noticed now one of them, Paul Forensic, signed one of them, who would have been Rich Colangelo's deputy. I don't recall the signature on the others, but if they weren't signed by Rich Colangelo, they would have been signed by somebody just underneath him.
And were some of those arrest warrants signed after the second interview?
The second and third arrest warrants were signed not only after the second interview, but after the third interview.
And one of the arrest warrants was for conspiracy to commit murder, correct?
That's correct.
Would that be inconsistent with the statements made by Attorney Colangelo in the second interview?
Objection leading.
I don't think it is. I'll allow it.
Yes, and it's also inconsistent with his representation on the phone on June 2nd to Attorney Bowman that if she didn't cooperate and the body was found, he was going to charge her with murder.
And without an agreement or any protection, what's the value of Richard Colangelo's statement in that second interview that he doesn't think that Michelle Troconis knows anything? the legal value of that.
There is no legal value,
Okay.
as demonstrated by the fact that she suffered 2 more arrests.
And
You know, I'm going to move, with all due respect, to strike the last portion of the answer because it is it is irrelevant. It is a question where the attorney, the witness, is arguing with the benefit of hindsight.
Right. I think it was responsive to the question, what's the value of it? Overruled.
you were asked at the beginning this morning, it was a while ago now, about F. Lee Bailey and some materials you read by him. Can you give us a sense of how important those documents or the treatise by F. Lee Bailey or the treatises were to your broader opinion?
Sure. Those, if Your Honor, please, those were not weighty factors or weighty sources in the formulation of my opinion. They just were additional materials that I took stock of.
Fair to say you expressed an opinion today of F. Lee Bailey's skills as a trial attorney.
Yes.
Does knowing that he'd run into troubles later and was disbarred undermine your opinion of him as a trial attorney?
No, because those books and treatises were written many, many years before he ever had his legal problems.
And going into what you considered or what your opinion was based upon, things that you looked at, we went through them last week. I don't know if you remember that, but we talked about some general things that you looked at. For example, the defense function standards under the ABA.
Mm-hmm. Yes.
I don't know if we went through the specific numbers and points on those, but do you recall what the specific defense function standards you reviewed were?
So if Your Honor, please, I reviewed the defense function standards with an eye towards identifying those standards that referenced or discussed cooperation. And I found 6 standards. They were 4.
I'm going to object. This is asked and answered, and this is part of the testimony from the direct.
Well, the second statement that that the witness was beginning to make, I think, went beyond the question.
Okay. Kind of asking a little bit about what the opinion was based on and how much of it was Mr. Bailey's opinion. Do you have specific standards that you reviewed that were apart from the Bailey treatise?
Oh, yes, absolutely.
Okay. Do you know the specific defense standards that you relied on?
Yes.
Can you just tell us maybe the numbers of them?
Yeah. Okay. So in the defense function standards, I found 6 standards that referenced or discussed a lawyer discussing with a client cooperation and or the advantages and disadvantages of cooperation. The standards were 4-1.3, 4-3.3, 4-3.7, 4-5.1, 4-5.2, and 4-6.2. Now, some of the standards indicated that a lawyer should discuss the advantages and disadvantages of cooperating with a client. And in standards, instead of using those 2 words, they use the words risks and benefits. But I found that those statements, those standards were informative, and certainly they were a lot more recent than the books and treatises written by F. Lee Bailey many years ago. I also took stock of the Connecticut rules of professional conduct, and those contributed to my opinion about the need to discuss with the client the advantages and disadvantages of meeting with the police.
And moving to the Judge Randolph's decision and the hearing that took place for the criminal trial, clarify, did you testify in that hearing?
No, I did not.
And are you aware of, based on what was shown to you or the records you reviewed, that there was a limitation on what trial counsel was able to present about ineffective assistance of counsel in that suppression hearing?
I was sitting in the hallway. Attorney Schoenhorn came out and said the judge is not going to permit Schoenhorn, to present me as a witness. And I learned at some later point in time when I started searching in the transcript for the judge's reasoning that it had been discussed in chambers and it didn't appear in the transcript. And I think that's where, because obviously I saw a transcript today dated December 18th, but it may have been at that point when I was told that the judge in effect told the lawyers he wasn't going to present it. It was said in chambers, and
Yeah,
that
I'm
may
gonna
have been
object.
why I stopped searching.
I'm objecting because whatever was discussed in chambers with Judge Randolph and the parties would be hearsay. This witness was not present for it. He is speculating. It calls for conjecture.
There was an attempt to impeach Attorney Fitzpatrick on somehow not understanding what had happened in the criminal court in this proceeding. And I think he should be allowed to answer.
I'll allow it in for what the witness here understood, but not for the truth.
Do you have more to the answer, or?
No, I looked in the transcript. I didn't see it. I was curious. And then I forget who told me, but the judge had in effect made a ruling in chambers, and that's why I wasn't finding it. But obviously I saw a transcript today that may prove that wrong.
And you're asked about specific findings or words that were made in Judge Randolph's decision. You remember that today?
Yes.
I'll just use one example. The conclusion about whether Mr. Troconis was fatigued. Is it necessarily the same analysis for an attorney looking at their client, preparing them for a decision to make as what a court might look at after a hearing and a motion to suppress?
Yeah, I'm going to object to the form of the question. I can't understand it.
I did understand it. If the witness does, you may answer.
Yeah, I think there is a distinction. You're talking about a historical fact, whether somebody is fatigued, but how that fact relays to an argument about coercion and voluntariness under the Fifth Amendment or the Due Process Clause is different from how that historical fact may connect with a claim of ineffective assistance.
And your expert disclosure was discussed today.
Yes.
Do you remember how many pages that was?
No.
And that was something that was filed by Mr. Troconis' attorneys, correct?
You and Attorney Patterson.
Okay. And you reviewed it. There was a discussion about it. Is that fair to say?
Yes.
Okay. And I think you agree that the word handcuffed should be stricken from that disclosure. In hindsight, it should be corrected, right?
Yeah. Yes, it doesn't square with the videotape.
Okay. But you weren't asked about any other words in that disclosure, correct?
No.
Did Attorney Zentner ever reach out to you about your testimony in this case?
No.
Did Joanne Sulik ever reach out to you about your testimony in this case?
No.
Did Attorney Sarah Jones ever reach out to you about your testimony in this case?
No.
Okay. And you were asked about how helpful it would be, or if it could have been helpful to talk to Attorney Bowman about his representation before you testified here. Do you remember that?
Yes.
But you also sat through a significant amount of testimony from Attorney Bowman. Is that fair to say?
That's correct.
Do you expect that there would be something, is there anything specific that you would expect to learn from a conversation that would be important to your opinion that you didn't hear in the testimony?
So I think last week I answered the question by saying if I had interviewed Attorney Bowman, it's possible it might have influenced my opinion. But as I think more about it, my opinion is based on the record that I reviewed, as well as the testimony given in this courtroom. And that includes Attorney Bowman's testimony. And there's no reason for me to believe that if I had interviewed Attorney Bowman before the hearing at his office in Westport, that I would have heard anything different then than I heard now in this courtroom. So I don't think if I had interviewed him, I would somehow be giving a different opinion today or a few days ago.
And you were asked on cross about whether you had any idea what the substance of the interviews between June 2nd and June 6th were between Attorney Bowman and Mr. Troconis. Do you remember those questions?
Yes.
Fair to say you have some idea of what the contents was?
I'm going to
Sustained that
object
ground of leading.
and mischaracterizes too. So I second ground.
I've already sustained it.
Only what I learned through
I
is...
sustain the objection.
Oh, I'm sorry, Your Honor.
Did you use the information that Attorney Bowman testified to about the June 6th interview in formulating your testimony, in your opinion?
Yes.
Um, talk a little bit more about some questions that you had in the first part of cross-examination about the Miranda waiver, the truthfulness. You just clarify best I can. Is the Miranda waiver sufficient advice for a client that's represented by counsel about those issues related to truthfulness and those other parts of the waiver?
The Miranda waiver and the advice to a client that if you sit down with the police, you cannot lie and you can be prosecuted for lying is indispensable. But that's only half of the equation. The other half of the equation is the notion of self-incrimination. In addition to telling the client that you can be prosecuted for lying, you have to explain to the client that since you don't have any protection, you have no agreement whatsoever, any arguable truthful information that you provide can expand your liability. It could have made the case against Michelle Troconis on the existing charges worse. It could have led to new charges. It could have led to a homicide charge. So it's not just a matter, Your Honor, of saying to the client, look, when you go in there, you have to tell the truth. And if you don't tell the truth, you're going to get prosecuted for lying. You have to, and you can't say it enough times. You have to say to the client, you really need to think twice about this because you're going in without any protection of any sort. And the truthful information that you give could get you in trouble too. And that's what happened in this case.
You're asked some question about the ability to advise someone and maybe I think about not reviewing the warrant with them before an interview. Would a reasonably competent attorney purposefully not review an arrest warrant to somehow preserve their client's credibility in an interview?
A reasonably competent attorney would review the arrest warrant with the client. If tailoring is a concern, it's a lesser evil than having a client submit to an interview without knowing the basic allegations, factual allegations underlying the existing charges.
And could the review of the arrest warrant contribute to the advice about whether to sit for the interview at all?
Absolutely.
Can you tell me a little bit about that?
Well, an arrest warrant affidavit generally contains great detail.
And so, bouncing around a tiny bit, but trying to go in order. You're asked about the Morant case. And you said that there were some facts that were incorrect about that, how things happened. Can you expand upon that now? About the order of events related to when the affidavit was filed and what had occurred in the case?
Well, I know factually when Attorney Bloss was appointed to represent Mr. Morant in post-conviction proceedings, I was no longer representing Mr. Morant, but I knew a lot about his case, and I told Attorney Bloss that I was more than willing to assist him. The affidavit that was filed later on in subsequent litigation. Yeah.
And there was a discussion about your disagreement or maybe slight disagreement with the idea that there's countless ways for a criminal defense lawyer to try a case versus maybe a more limited view of that. Can you expand upon that a bit?
Yeah. Well, I think it has to be recognized that this case is not about Attorney Bowman's performance at trial, but in terms of Justice O'Connor's statement in the Strickland case that there are countless ways to try a case.
I'm going to object that mischaracterizes the testimony. Justice O'Connor's opinion said countless ways to represent a client, not to try.
All right, if that's the case, then you could rephrase the question.
I'm fine with him answering as corrected. Thank you, Attorney Zentner.
So I'll break it down this way. There's three basic outcomes in any criminal case. You're either going to go to trial, you're going to plea bargain, or you're going to pursue a nollie and a dismissal. If the case goes to trial, I do not agree that there are countless ways to defend the case at trial. To me, countless means unlimited. My view is that generally speaking, there's probably about a half dozen ways that reasonably competent lawyers could defend a case at trial. That's my view. Not unless you want to get into a situation where you argue that changing one question or one line of questions, one line of questioning amounts to a different strategy. My view is there's probably about a half dozen ways that a lawyer can try any given criminal case.
Would you disagree with the element of the O'Connor decision that says there's not one way to try a case?
Objection.
I do not disagree with that.
Hold on.
That was not in the Strickland decision. There's one way to try a case. She said, Justice O'Connor said in the decision, there are countless ways to represent a client.
I'm just trying to clarify where the disagreement was. I can move on.
I don't have the case in front of me, so depending on representations of counsel.
Yeah, I don't quarrel that's in the opinion, that statement by Justice O'Connor.
And I don't want to misstate what the exact question was, but I believe you were asked something about the need to consider all possible explanations for counsel's actions when judging the reasonableness of their conduct. Do you remember that question earlier today?
I think so.
And I believe you disagreed with the assertion that all possible justifications should be considered when considering whether counsel's actions were reasonable. Remember that?
Well, the justifications don't come from any of us. They come from the lawyer himself or herself. They come from Andy Bowman. He's the one that provides the explanation for why he did something or didn't do something.
And we have, well, you heard his testimony about his reasoning, right?
Yes.
And your opinions are centered to the reasons given in court here?
Say that again?
Your opinions about the reasonableness of his actions, are they based upon what Attorney Bowman himself said about the reasons for his actions?
They're based on his testimony as measured by the prevailing professional norms.
I'm not trying to cut you short at all.
No, I didn't.
But are you
I didn't even. I am
close to finishing redirect?
I am close to finishing redirect, but I kind of lost track of it. There's an afternoon break we haven't had. Probably 10 more minutes. I don't know if happy to do it now, but okay.
How much recross do you think you'd have, Mr. Zentner,
Well, so far,
so far?
I'm gonna be conservative and say 15 to 20 minutes.
Okay. All right. I think we should take our afternoon recess till 4 p.m. Stand at recess. Good afternoon. Please be seated. Good afternoon, sir.
Which one has the?
Is this one big one?
Continued redirect examination when you're ready, Mr. Brown.
Just a few more questions. You were asked a question about terminating an interview and the advisability or the wisdom of doing that.
Yes.
You familiar with a case called Doyle versus Ohio?
Yes.
Can you tell me about that?
That's a United States Supreme Court case where the United States Supreme Court held that negative inferences can't be drawn from a client's exercise of the right to remain silent.
And you were asked some questions on both sides about the decisions being made. I asked you some questions about the basis for the decision being made. You were also asked on cross about deference given to strategic decisions. Do you remember those questions?
Yes.
Is that deference unlimited?
No, it's not.
What's the standard for judging strategic decisions?
The decision making in order to be, for lack of a better way of putting it, insulated, needs to be sound decision making.
And were you able to determine the strategy from Attorney Bowman through his testimony and other parts of the record?
Yes.
And was that a sound strategy, in your opinion?
That was not a sound strategy. That was a flawed strategy.
Nothing further. Thank you.
I may have a moment, please.
When you're ready. Yes.
Confirm.
Attorney Fitzpatrick, in this case, Ms. Troconis was never charged with accessory murder.
I'm sorry, say that again. Never
Yes,
charged with accessory murder?
Yes.
That's correct.
Now, on the transcript that you said you had reviewed from December 18th, 2023, where in the transcript does it reference anything involving a in-chambers conversation with Judge Randolph and the parties?
It doesn't. I'm sorry if my testimony was confusing. I thought what I had said is I was told that by either John Schoenhorn or one of the other lawyers. Yes, that is not in the transcript that issue was taken up in chambers.
And you would agree with me that what Attorney Schoenhorn told you, assuming it was accurate, is still hearsay nonetheless, right?
An expert can rely on.
Well, that's really for me to determine. So construing that as objection, I'll sustain.
You understand that during the first interview, I'm withdrawn. You understand that during the first interview of June 2nd of 2019, Ms. Troconis was offered food, water, and she accepted a blanket.
I think that's correct.
With regard to the notice of rights form, you said you looked at it in this case?
Yes, I believe I did.
Fair to say that the rights that Ms. Troconis was advised of comports with the United States Supreme Court landmark decision in Miranda versus Arizona from 1966.
I think, first of all, what I looked at was a copy of the substitute notice and waiver, because the original, for one reason or another, was apparently lost. But if you're asking me if the copy, the English version, comports with U.S. Supreme Court case law, yes, it does.
Okay, well, the notice of rights form, let's be clear for the record. The notice of rights that Ms. Troconis signed was still offered in the suppression hearing. It was the waiver that could not be found. Is that your understanding of the record?
My understanding of the record was that the original document had been lost.
Okay, I want to distinguish, though, Attorney Fitzpatrick. You would agree there is a difference between a notice of rights and a notice/waiver of rights, correct?
Yes, but typically they're in the same document. The notice is on top and the waiver is on the bottom.
In this case, however, the prosecution did introduce a signed copy by Ms. Troconis involving the notice of rights. Are you aware of that?
You mean at the original trial?
Yes, and at the suppression hearing.
Yes.
Okay, the signed copy that she made, right, of the notice of rights. I can show it to you if you'd like to refresh your memory.
Yes, if you would, please. So you and I are talking about different things.
Okay, this is the notice of rights that's in your hand, correct?
Correct.
Okay. On that notice of rights, when you look at the top portion that's in English, that would comport with the dictates of Miranda versus Arizona, the landmark case from 1966.
That's correct.
And on that form itself, not so fast, on
Yep.
that form itself, the rights are also advised in Spanish, correct?
That's correct.
And just so we're clear, Attorney Fitzpatrick, on the seminal case of Strickland versus from 1984, I think Justice Sandra O'Connor said there are countless ways to provide effective assistance of counsel. Would that be fair? Would that be a fair recollection of what it said to you, as far as you know?
I'd have to look at the specific language.
Yeah, deal. We just have a moment, please, Your Honor.
Yes.
You remember earlier in your testimony, I'm sorry, on redirect examination, you referenced that expert disclosure that was submitted just last month in December of 25. Do you recall that? The expert disclosure of you, that you were going to testify. There was an expert disclosure document. Remember that?
Yes, I was asked about that today.
Okay. It's fair to say that when that was filed, you had already made up your mind concerning whether or not Mr. Bowman had engaged in deficient performance.
That's fair to say.
So without even seeing Mr. Bowman testify, you had already made up your mind.
I had already formed an opinion before he offered testimony in this case.
Do you remember Rule 4? I'm sorry, may I just one more. In about 5 minutes, I will conclude my recross, I think. I'm trying to bring something up on the laptop, Your Honor. I'm sorry. You cited a number of standards on your redirect. Those were, for the record, you enumerated, identified a number of them, Attorney Fitzpatrick. The ones 4-1.3, 4-3.3, those are specifically what?
Those are ABA standards, ABA defense function standards.
Okay. Let's go to standard. Let's talk about the standard of 4-3.7, which is entitled Prompt and Thorough Actions to Protect the Client. Okay.
Yes.
You said you're conversant with that.
Yes. Yeah. Subsection E is the section you want to be looking at.
There is a subsection E,
That's
Right.
correct.
and it says defense counsel should consider whether an opportunity to benefit from cooperation with the prosecution will be lost if not pursued quickly. And if so, promptly discuss with the client and decide whether such cooperation is in the client's interest. Counsel should timely act in accordance with such decisions. Right?
That's subsection E.
Correct. Okay. I just want to make sure you were conversant and he had seen that subsection. And I would respectfully ask the court to take judicial notice of that.
It's in the brief. I'll look at it.
It's a-
Yes.
I appreciate the indulgence, Your Honor. That concludes my recross-examination of Attorney Fitzpatrick.
Mr. Fitzpatrick, you may step down. Your excuse.
Thank you, Your Honor.
Safe travels. Further witnesses, Mr. Brown?
No, we do not have further witnesses. However, before we rest, there's an issue of a few exhibits that have been discussed. I'm trying to think what the court's pleasure would be as far as we can rest with that, leaving just the exhibits open, or we can handle the exhibits and then formally rest some other.
Right. I'm not concerned with that, and I won't hold you.
Yes.
But if it's something we can do now, let's
Yes.
do it.
So the first issue, we discussed the first one in chambers. Exhibit 26, I don't know that we formally put this on the record, but long story short, there was different versions of transcripts. We got one version from Legal Services Unit. We looked in the appellate brief, and in that transcript table, it said don't use the 61-page version. We've now replaced it with the correct 80-page version or 81-page version. That's December 18th, 2023.
Right. So we have an 80-page version of Exhibit 26.
I think it's already full. I just got to know that we have actually.
If I may supplement, Your Honor, it's the transcript of December 18th, 2023. That full 80-page version is Exhibit 26.
Right.
The shorter, incorrect version is embedded in one. I don't know whether it's one of the first numbered exhibits that run from date to date. It's part of the suppression hearing transcript. So the 60 pages of that date that are embedded in an earlier numbered transcript, that's not the right transcript. Exhibit 26 goes in its place.
Judge, so the record is
Right.
clear. We have no objection to Petitioner's Exhibit 26.
Admitted in full.
We have a moment with Attorney Brown.
There's an agreement on what will become 28, which is videos that were full exhibits of the criminal trial that were referenced by Attorney Langlois and Starbucks. We can handle that with the clerk. There's agreement upon that once we give an appropriate flash record.
27.
I'm told it should be Exhibit 20.
27, sorry.
27 for the flash drive.
So no objection from the respondent. Exhibit 27, which consists of video.
And then what we don't have ready. What we need to know. Do you want me to do this? Yes, but that doesn't.
In the one last final exhibit matter, I think there's an objection, but there's a February 7th, 2020 transcript in the criminal proceedings that's the first pretrial proceeding where it's appearance. It wasn't earlier discussed. There's an objection, but
It's an objection because I think the transcript is outside the purview of the parameters of the amended petition filed last year, Your Honor, in 2025.
Right. I'll overrule the objection, admitted in full. The date was February 7th,
2020.
2020.
Upload that
soon as we get there.
Okay. And with that, once that perfected, we rest subject to perfecting the exhibits.
Right. That's understood. I'm not gonna
Yep.
gonna say you can't submit the exhibits even though you've stated you've rested. So petitioner rests, as we've discussed in chambers. The respondent's going to decide whether to present evidence Thursday by midday.
That was all our understanding.
Right. And if so, we will let the public know that we will resume Friday, hopefully at 10 o'clock. If not, then I can tell counsel and other interested persons that I will put in an order for the filing of briefs. Both parties will file simultaneous briefs and then file simultaneous reply briefs. That will be sometime after the transcript of this trial has been provided, when the after the second round of briefs has been filed. Then my period of time for writing a decision will start to run. I will have a decision in writing. I do not anticipate taking the full 120 days to decide the case, but I will obviously have a lot to consider. In the event that we do not meet in court Friday, I do want to thank counsel for their courtesy toward the tribunal and for their professionalism in all respects. Is there anything else that we need to do on the record?
I did upload, the court may recall earlier today, I mentioned there's like 8 cases I was going to cite from foreign jurisdictions marked for ID. They've been uploaded, submitted to the clerk. The court is aware, as all the parties are, anything could be marked for ID.
Right.
So I can list them, but it's already been done. I just want to alert the court.
All right. It's noted that they're marked for ID only, but you're free to cite them in your brief.
Thank you.
Okay. All right. Anything further from counsel?
No, Your Honor.
All right. Stand adjourned.